International. Sir also provide mentorship and guidance to the arbitration enthusiast. Sir is a steering committee member and co-chair of Asia Pacific region of Greener Arbitration, also a committee member of BI, Asia International Arbitration Center, Singapore. Sir has been recently appointed as a co-founder of India chapter of Energy-Related Arbitration Practitioners, ENE-RAP. And I would also like to introduce a second guest speaker for the session, Ms. Chinmayee Pendse, ma'am. Ma'am is a counsel at Chambers of Karishma Vora. As a dual qualified lawyer, ma'am specializes in cross-border commercial disputes under English and Indian law, and has represented clients in international arbitrations governed by ICC, LCIA, SIAC, and LMAA rules. Ma'am is an alumna of Government Law College and the London School of Economics, where pursued their LLM in international business law. Ma'am also served on the core committee of CIARB's Young Members Group in India. As this session will be an interactive session, I request every participant to kindly use raise hand option prior to replying or asking something, and we will accordingly unmute the respective participant. And if they are comfortable, they can post their questions in the chat box also. Now, without any further delay, I would like to invite Mr. Sameer Shah sir and Ms. Chinmayee Pendse ma'am to share their valuable knowledge on what attributes or elements must be taken into consideration while drafting an arbitral agreement, and request respected guest speakers to eliminate everyone present over here on today's subject. Over to you, sir and ma'am.
Thank you, Nikhil, for that kind introduction. A warm welcome to all the participants. Today's session, as Nikhil informed you all, and you would have also been circulated with the brochure information, is on arbitration agreement. Now, before I start my talk on what is an arbitration agreement all about, I would like to quote a very important and, of course, relevant observation made in a book on international commercial arbitration by Mr. Gary Bourne. I mean, his name doesn't need any introduction to those who knows international arbitration. He is one of the most renowned international arbitrator. And I quote what he said in that book. Disputes have a critical impact on the international commercial dealings. Properly handled, contractual disagreement need not jeopardize and can enhance a company's bottom line. Handled ineffectively, disputes can produce unjust or disproportionate liability, extravagant legal cost, adverse publicity, and much worse. Now, keep this in mind as we go through this session, and you will realize how relevant Mr. Bourne has made this observation in his book. Now, this observation is not only applicable for international commercial arbitration, but even from a domestic arbitration perspective. Therefore, the key is how to effectively manage disputes. And this key lies in drafting a proper, valid, and effective dispute resolution clause or agreement in the contract. Now, you see, due to the quite a high rate of increase in the global trade and the commercial activities intersea between the countries, which of course had led to the proper prosperity and affluence, has also brought in increased disputes. I mean, it goes without saying that where there is business, there is always a dispute. Disputes follows business. And therefore, you see, every business, almost not every, I would say, but majority of the businesses, they have to face these disputes, cross-border disputes, if we talk from the international perspective, or in fact, inter-sea dispute, if we talk from a domestic perspective. Now, more from the international part or even from a domestic aspect, neither party would like to face either a foreign court or a court from a different state, because they don't have either the knowledge or they don't have the option to avoid a bias or that particular jurisdiction or that particular court. The cost of facing the court of law and consequences of losing can be substantial. And therefore, now, at least in our country, and it has been going on since many years in international transactions, every commercial contract, therefore, must raise this question of where and by whom the disputes under it will be decided. The answer to this question has a direct impact on the final outcome of the dispute. A dispute can have different outcome in different courts of law. You would have, heard about this while going through the judgments or during different talks and events. Procedural laws, substantive and other legal laws or rules, integrity, competence, language, local bias, so on and so forth, are some of the important issues that have direct impact on the dispute before the court of law. Because of these issues, therefore, it is always advisable to incorporate a dispute resolution clause in the commercial contracts so as to significantly at least reduce these uncertainties. Now, having laid down this basic outline of our today's session, let us now go to what is an arbitration agreement. Now, when we talk of an arbitration agreement, before we actually understand what the arbitration agreement is, let us first understand the purpose of what do we denote when we say an arbitration agreement. Basically, we are talking here of forum selection. Forum selection in the sense of whether to refer or to get that particular dispute adjudicated through the traditional litigation system, that means approaching a court, or to get it adjudicated through any of the ADR processes, mainly arbitration or mediation. So when we look at, or when we do a small comparative analysis of these two forums, if we put litigation or the court on one side and arbitration, let's say, since the current session is on the arbitration part. So if we put arbitration on the other side, and if we do the comparison, then certainly in many aspects, arbitration way much more higher than traditional litigation process. Let me give you some examples of this. First and foremost, party autonomy. You would have heard this term, those who have gone through learned the subject arbitration or in general talk. Party autonomy. What do you mean by party autonomy? Basically, party autonomy means that it is the parties themselves who would decide the whole process of how their dispute would be resolved, the whole procedure. If you have the barracks right now with you, and if you just open it up and start reading, especially after section 18 onwards, many of the sections you would find these peculiar words at the very beginning, and those are unless otherwise agreed by the parties. Yeah, what does it mean? it actually denotes this principle of party autonomy. Meaning thereby, if the parties have agreed, then that will be the process. Yeah. So party autonomy, that is what is the one of the most major advantage of arbitration. That you will not find in the court, because court is bound by set process, set procedure, set law. Court has to move within the four corners of laid down law. Let me tell you here that though the act is said, it's an act, the Arbitration and Conciliation Act, but it is actually a procedural law. Because if you go through that, it doesn't lay down any law as such. It lays down the process, the procedure, how an arbitration would be conducted. Yeah. So it's a procedural law, and therefore it has that much flexibility and bound to be. Otherwise, why a person or a party should go out of court and choose this forum? You need to give that flexibility to the parties, because you are giving the choice of forum to the parties. Therefore, this flexibility is there in arbitration, which is not there in court. Secondly, confidentiality. Another very important aspect of arbitration, or ADR, other ADR process as well. Because in arbitration, what happens remains within that four corners of that room. Between those parties, no third party is allowed unless permitted by the parties themselves. In court, it's public forum. Anyone or anybody can walk in and sit and listen to what proceedings are happening. Yeah. So it's public, it's open. Third, neutral process. An arbitrator is a neutral, impartial individual. Though there are both sides of it, but let's not go into that debate as of now. First, understand the basics, and then we can go in details about it later on. So let us first understand the basics. So it's a neutral process. Yeah. In court, we all know what level of neutrality we expect from court. Yeah, I think that is enough for me to say at this stage. Another advantage, commercial expertise or subject expertise in arbitration. An arbitrator, you can nominate a person who's expert in that particular dispute to adjudicate that as an arbitrator. Now, this choice or this flexibility of freedom is not there in court. A judge may not be expert in that particular dispute, but he is still a judge, and you have to be there. You don't have any choice. But as a party, you have a choice in arbitration to choose a particular subject expert for that dispute. Another, and not the least, speed. Let me tell you, if you are not aware, our act is the only act which under law prescribes timelines of passing a final award. 1 year, 12 months. Of course, from the date of the completion of pleading, which is obviously again restricted to 6 months from the date of commencement of arbitration. So practically speaking, 1.5 years is the bottom line for the tribunal, sole or a panel, to issue the final award. Can you expect this in a court, especially in an Indian court? Though we have now the Commercial Courts Act, we have the special commercial court benches, still, can you expect this speed in a court of law? Obviously not. And it is obvious, it is very much justified because the court is bound by law. So they have to follow a set process. Here, as I said, it is one of the most flexible process, because if you go in section 19, it very clearly says that the tribunal is not bound by CPC or Evidence Act. Now, mind you, you have to understand the implication of not bound. It doesn't mean that it doesn't apply. But so what does it actually means? That the basic principles would apply. It is not that you have the tribunal has to hold a full-fledged trial like a court process. No. So that's why there is a speed. So therefore, when we are talking of arbitration and arbitration agreement for that, this is what the advantage we get as a party. So now let us go to understand what arbitration agreement is. Now, if you have the barracks, if you open section 2(1)(b, now I understand and that most of you would be the student of law, and you would know and you would agree that majority of the acts or regulations or law, provisions would start with a definition clause after the preamble and object and reason. Now, this is one of the peculiar act where, though it says a definition section 2, but it fails to define actually major terms. And section 2(1)(b) is a vivid example of that. What does that say? It says arbitration agreement means an agreement as defined in section 7. This is the definition. You go to other subsections, subclauses, you will find the same. So it actually doesn't define, and rightly so, because as I said, it's a procedural law. Yeah, it's not a substantive law. It's a procedural law. Still, so this is the peculiar aspect of this act. So let us now go and see what section 7 says. Now, in the last session, Mr. Arush did refer very briefly to that particular section. So let us open that section, because as it deals exactly and very precisely with an arbitration agreement. It defines what an arbitration, it not defines, I would say, but at least makes an attempt to define what an arbitration agreement is. Yeah. So let us open section 7 and let us see what it has to say. Now, if we read that section, it says arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between the parties in respect of a defined legal relationship, whether contractual or not. Now, we all have read it, simple. Now, you have to learn the art of reading any provision of law if you really want to understand what that provision says. And how you do that? You have to learn where to break or where to go. And that is why, mind you, very few times you would see a comma, which gives you an indication of taking a little bit of pause. But you still have to, even if there is no comma, still you have to break somewhere, to break it in pieces to understand what actually it means. So let us do that here and understand what this section actually means. What is an arbitration agreement? It says means an agreement. So we have to first understand what is an agreement. Now, you don't find it here. To understand this, you have to go to which act? Can anybody just say? Which act we have to refer if you want to understand or what is agreement? No, Chinmayee, not you. Not you. It is for the students. Yes, Shivam, you said ICA. What is that? Don't use short forms. Indian Contract Act. That's which section? Yes. Quickly Google out, find out section 2H. Shreya, can you just say it aloud? What that section says? Can you just unmute? Who's the moderator? Nikhil, can you just unmute her? Shreya?
Oh, yes, sir. Yes, sir. Sir, it says any agreement which is enforceable by law is a contract. Okay. You're talking about agreement.
That's it. This is what I
2A.
said.
It is 2A.
Yes. So what is 2A? What
Sir,
is 2A?
agreement. Sir, it is a promise. A promise made by the promise. A promise enter and a. I forgot.
Doesn't matter. Samanvi,
I
am I
can.
right? Yeah. There's somebody else. I think Samanvi or somebody. I just saw that. Can you just unmute her, please? Nikhil?
So they all can unmute themselves. The option is there.
Okay. Anyway, I think let's not waste time on it. But yes, so to understand what is an agreement, you have to refer to the Contract Act. Correct? The Indian Contract Act. That's how we go. So assuming that we know what is an agreement, what an agreement is, let's go further in this section definition. By the parties to submit to arbitration. So that is the agreement. What? To submit to arbitration. So there is a clear understanding between the parties that something has to be submitted to arbitration. Yeah. Now let us see what. All or certain dispute. Now, mind you, this is very important. It may be a case that the parties would decide that okay, we will just refer only some disputes within the contract to the party to the arbitration, not all. For some, we may approach the court or we may go with mediation. So this is also important. So it is not necessary that all dispute can be referred to arbitration. Yeah. It is only what the parties have agreed to the reference. Those disputes only can be referred to arbitration. So that's why it says all or certain disputes which have arisen or which may arise between them, meaning thereby present or future. So there can be a agreement between the parties post a dispute have arisen. Or it can be an agreement between parties before any dispute arose between the parties. Yeah. So it is both present and future. In respect of a defined legal relation, again, you have to go back to the Contract Act and understand what is an agreement, what is a contract, validity, invalidity, void. So that's why, again, I'm saying this is a procedural law. It does not actually define. It is not a substantive law, unlike ICA. If I use your short terms, ICA. Yeah. Now, this is a initial part of understanding what an arbitration agreement is. Now, to put it in a simple language, this is all you also have to learn. You see, legal language is obviously many times quite confusing. I mean, confusing from a layman's perspective, but even from a student perspective also. Before you actually understand these legal aspects, try to make it in a simple form. It will be easier for you to understand it. Yeah. Of course, you have to learn these legal language and legal jargons, no doubt about that. But for your own understanding and also for explaining to the others, formulate it in a simple way. Don't get confused with these legal aspects of it. Now, if we put that in a simple in a simple understanding, in simple language, English of understanding, what is an arbitration agreement? So it is a mode by which two or more contractual parties voluntarily agree to resolve their dispute finally through a neutral and impartial person or decision maker who applies adjudicated procedure for finally resolving the dispute by giving the parties an equal opportunity to be heard. I'm sorry for this background noise because of these some repair work going on. Please excuse me for that. Now, so this covers the whole aspect of an arbitration agreement or a clause for that matter. Now, going back to this very important aspect is that there is a finality to the issue, in the sense that arbitration or the arbitrator or the panel must decide the dispute. This is where arbitration differs from other ADR processes like mediation or conciliation, because in arbitration there is a finality to the dispute. They have to, the arbitrator or the panel has to deliver the final decision. Of course, as per the procedure which is agreed by the parties or as made out in the act. Yeah. So this is what an arbitration agreement looks like. I mean, this is what the meaning, in fact, we are yet to go into what an arbitration agreement is, but this is what the meaning of arbitration agreement in a nutshell. Going further in section 7, it lays down certain important ingredients of an arbitration agreement. First and foremost, and very important, and as it was already mentioned in the last session also, it has to be in writing. That is very important. It cannot be oral. Yeah. Then, yes. It can be in form of a clause or a separate agreement altogether. Right? I think that's very easy to understand. And then it also lays down if different modes of writing. If it is in writing, then either a document is signed by the parties or there is an exchange of emails, other form of communications, from which it can be inferred that the parties have agreed to refer the dispute to arbitration. Yeah. And then it can be also by exchange of statement of claims and statement of defense, where neither parties are denying each other, at least those statements or the reference. So by inference. These are, important ingredients of an arbitration agreement. Much detail will go in the next part of this session, but I am just giving you a basic outline of what arbitration agreement is all about. Now, if I just cover up and I say in one single sentence that arbitration agreement is a raison d'être. It's a French word which means the reason of being there. It is the heart of the dispute resolution process. Why? Because this agreement lays down or in fact controls the whole procedure of arbitration. It lays down the boundary within which the parties and the tribunal has to play. A tribunal, unlike in a cricket match, cannot hit a six. There is no six. If it hits a six, it will bound to be set aside under challenge in Sec 34. So they have to play within the boundaries. So you cannot score sixes and fours. You have to be either one and twos. Yeah, you have to keep on running between. the wicket, which is this clause. So this clause, this is the importance of this clause. And that is why Mr. Bond, if we go back to that particular observation, he said that if you don't draft it properly, it can lead to such adverse consequences. You see, if we just look at the contract and dispute between parties, after the main dispute between the parties in the contract, the second most issue which is faced, or second most dispute which is litigated between the parties, is this clause itself or this agreement itself. Major part of the dispute between the parties is on this dispute resolution clause itself, unfortunately. Why? Because of the bad drafting. We'll see what is a proper drafting in the next part. But kindly keep this in mind, that it is the important aspect of an arbitration process. The whole process actually emanates from this arbitration agreement. That is why so much of importance, and that is why we have dedicated one full session on this important clause. Therefore, before I conclude, let me just give you two important aspects. One is what normal mistakes are made in drafting, and some important tips on how to draft. Because now onwards, in detail, the further aspect of this arbitration agreement would be covered by a very able, very talented, and intellectual person, Chinmayee, whom you can see there on the screen. So she will be doing further details on each and every aspect of what I have outlined to you. So as a parting tips to my presentation, by talk, you see what happens when we draft. Unfortunately, many times the drafter, they don't understand or appreciate the difference between the words may and shall. And it is because of this, it can lead to further disputes. So may, permissive; shall, mandatory. Understand and appreciate the difference. I'm just leaving you here because the detail, Chinmayee would definitely go into that. Second, many times, in case of an institutional arbitration, the clause contains rules which are, or the institution which are non-existent at all. They are not in existence. Yeah, we have come across. Now then it's a very difficult situation, and ultimately the matter lands up in the court. Now you see, the whole purpose of arbitration is that you come out of the court, but because of these mistakes in drafting, you ultimately you eventually land up in the court. Why do so? Adding to your cost and time unnecessarily. Then many times there are issues of not joining relevant parties or joining some irrelevant parties who are not at all relevant to the dispute, putting some clause, some kind of a time limitations or some ambiguity in the clause itself, not specifying the language, the law, seat, so and so forth. Yeah, these are the mistakes which one should avoid. And therefore, the tips, quick tips, and then Chinmayee will take over. Try to draft arbitration clause, preferably with multi-tier options of dispute resolution, but make it short and simple. Avoid generic and open-ended terms. Let me give you an example here. Let's say the clause is like this: in the event of a dispute, the parties shall use all reasonable efforts to amicably resolve the dispute through good faith negotiation. What does it mean? There is no end. There is no full stop. There is no timelines. How do you define reasonable efforts, amicable resolution, good faith negotiation? How do you define that? How can you limit? I mean, who's going to put a limitation? Each party would have their own subjective views on this. So a dispute will not be able to get resolved. And ultimately, it will end up in court. So avoid these kind of open-ended terms. Make it step-by-step escalation. Chinmayee would show you what a valid arbitration clause would look like. So I am not touching on that, but step-by-step escalation means negotiation, amicable settlement, mediation, arbitration. But put a finality. Put a full stop somewhere. Dispute must finally be decided. Yeah. So with that, I stop here. I conclude my talk. And as I said, now floor is yours, Chinmayee. Thank you so much.
Well, good afternoon, everyone. Thank you, JCRC University, and more importantly, Mr. Shah, for inviting me to speak today and for such a warm and kind introduction. And thank you very much to all the participants and students who are here on a Saturday afternoon, despite a 4-hour lecture already on arbitration since 11 a.m. So I'm hoping to try and make this more interactive and more fun for you guys so that you don't doze off without chai and food in your system. Mr. Shah has kindly given you a brief background on importance of drafting a good arbitration clause, and he's given you benefits of arbitration, and he's also gone through very kindly the Indian Arbitration Act and the provisions for an Arbitration Act. What I hope to do at the end of 1 hour is to armor you with sufficient knowledge to avoid glaring mistakes in drafting these clauses. So these dispute resolution clauses are colloquially often called as champagne clauses or midnight clauses. And this is because they're either negotiated or drafted after all of the other commercials are ironed out between the parties. Nobody cares about this dispute resolution clause once the commercials are ironed out. And some poor first year associate is stuck at midnight trying to draft this clause in most cases, right? And then what happens? What does he do? He will take up a previous agreement that he's drafted, cull out the dispute resolution clause and an arbitration clause from there, and paste it in this new agreement that he's asked to finalize because everybody else is celebrating with champagne and he's stuck drafting this clause. The problem is that no thought is given to this clause at all. And it is often treated like one size fits all precedent. And that doesn't really work well for anybody because the result is that you end up disputing about the dispute resolution clause itself. And that is something you would always want to avoid. Because a well-drafted clause will ensure that you mitigate all of the risks that parties will face at the first stage of their dispute as to which forum to go to, how to litigate, how to arbitrate, when to arbitrate, whether to arbitrate, and what to arbitrate on. And that is why, and that is what I'm hoping to convey to you today. Like I said, I would want to make this interactive, and the chat box is always open. If you have any questions, don't wait till the end. If you have anything to ask me, type it in the chat box, unmute yourself, and ask me your question directly, and I'll be happy to take it then and there. I've prepared a small presentation which will sort of help you understand and guide you through what I'm going to speak about. If my laptop doesn't give me technical difficulties, I should be able to pull it out. Let's see. Well, apologies for this. I should have done this sooner. So please may I bother you to email the presentation to one of the participants or the organizers, and they can put it out on screen.
Sorry, you want me to email to them?
Yes, if you can, then because for some reason I'm not able to put it up on screen. So if it can be emailed to one of the organizers, then they can put up the slides up.
Okay, let me just. I mean, meanwhile, you can just continue. I'll do that. Just,
I'm gonna continue in any case.
Yeah.
Well, so the first thing that we need to know is the basics, right? There's a checklist of what needs to be put in an arbitration agreement. I want to start with the scope of the clause. And by scope of the clause, I mean, what would that clause entail? Generally, arbitration clauses starts with any or all dispute arising out of or under this agreement. Now, these common phrases all have different meanings, and some are more broad than the others. And which is why this section of the clause is crucial, because it sets the boundaries for which disputes the tribunal is actually authorized to determine. Like Mr. Shah said, that the arbitration clause is the heart of your dispute. So the clause must state what the parties can actually refer to the tribunal. So the scope of this clause is very important. Then the other thing that the parties must determine before entering into this clause is whether they want to have an ad hoc arbitration or an institution arbitration. So the parties need to consider whether they want an institution such as the Mumbai Center for International Arbitration, for example, or the SIAC, which is the Singapore International Arbitration Center, LCI, ICC, which are the more popular international arbitration centers, or for commodity arbitration, say, for example, sale of sugar or metal, there are more specialized arbitration institutions like the Refined Sugar Association or the London Metal Exchange or the London Maritime Association. So what these arbitration institutions do is that they help parties set the procedure for the arbitration. So they'll have a set of rules, and if those institution rules are incorporated into your arbitration agreement, then your arbitration will generally proceed according to the rules of the institution, right? So the first thing the party needs to do is decide whether they want to have an ad hoc arbitration or an institution arbitration. The second thing the parties would need to do is figure out what is the seat of the arbitration. Now you have a session where it would, where they cover what is the difference between seat and venue in a lot of details. But for this purposes, remember that a seat is the most important provision of all. It is the law that dictates your proceedings. It is the procedural law of your arbitration. Um, the seat is important because whenever an award is made, it is the courts of that country's jurisdiction will have the jurisdiction to basically set aside this award. Those are the courts that will also have a supervisory jurisdiction over to give any ancillary reliefs in aid of the arbitration proceedings. So which is why nominating a seat is extremely crucial. um, if in an international arbitration, if there's an arbitration between an Indian party and a Singaporean party, neither of these parties would want to have an arbitration seated in either of their countries, because they think that one party would have an edge over the other party. So what they would do is that in such situations, most parties would apply for like a neutral jurisdiction, right? So a country which neither of the parties are nationals of, or places where neither of their companies are incorporated. And then this can be anywhere in Paris or Geneva or London for that matter, and the example that I gave you. But you have to remember one thing, that this seat is very different than a venue. So even if the parties say that the arbitration will be seated in London, for example, it doesn't mean that the arbitration actually has to be conducted in London. So not everybody has to go up and go to London to have this.
Chinmayee, sorry to interrupt you here. Akshit, what is the issue?
I'm sorry, sir. I'm sorry, ma'am, for interrupting. I just received the PPT. Should I share?
Yes, if you can, that would be great.
Sure, ma'am. I'm just sharing.
Thank you.
Is it visible?
Yes, it is.
Okay.
Okay. So if you can just go to the third slide, because that is where we are right now.
Okay.
No, just sorry, just for a moment, show the second slide. That's also equally important, Chinmayee.
Yes, so that is what I started with.
Yeah.
So
Yeah.
we're here to litigate the arbitration clause that was meant to avoid litigation. So like Sameer sir and I started telling you that you want to avoid being in this situation. The last thing you want to do is to litigate your arbitration clause, and that is what we're hoping to achieve by the end of the session. You would never put your clients into that position once you become lawyers. Right. So can we go to the third slide, please?
Yes, ma'am.
Thanks, Akshat. Right. So we were discussing the primary considerations or a core element that needs to be there as a part of your arbitration clause. The first thing we discussed was, well, the scope. The second thing we discussed was whether it should be an ad hoc or an institution arbitration. Then we were discussing about the seat of this arbitration. And we were at the point where I was telling you that your legal seat can be anywhere as per whatever is defined in your clause, but that doesn't limit you from conducting your arbitrations anywhere. So even if your seat says the arbitration is seated in London, you can still have an arbitration in, I don't know, Paris, or you can have it virtually where parties are appearing from all different places. So venue is very different from the seat, right? So when you're choosing your seat, it is also very important to ensure that the seat that you're choosing is a party to the New York Convention. Now, I'll tell you why that is the case. This is important because when an award is made, firstly, the courts, you go to that country's courts to challenge it. That's one. But where do you go to enforce this award? You go to enforce the award wherever the party against whom the award is made has assets across the world. So tomorrow, in the example that I gave you, if an Indian party and a Singaporean party has an arbitration seated in London, because that is a neutral venue, and the award is made against an Indian party, right? The Indian party loses. Now, this Indian party has assets only in India. It doesn't have assets in London or in Singapore. So that award that is made in London has to be brought to India to be enforced in India, because the Indian party's assets are in India. Now, the way this is enforced is through obviously your Indian Arbitration Act, but more importantly, internationally, the convention which is called as the New York Convention for Enforcement of Awards, which is adopted by the Indian Arbitration Act. And therefore, any seat that you choose has to be a country which is a party to the New York Convention, because that enforces smooth enforcement of awards. So, for example, tomorrow, if you choose the seat of arbitration as Yemen, for example, then it would be very difficult for the Singaporean party who has gotten an award against an Indian party, but the award is made in Yemen. Yemen is not a party to the New York Convention, so that award cannot be brought to India and enforced under the Indian Arbitration Act, because there is no reciprocity, and neither is Yemen a party to the New York Convention, which is why it's important to choose a seat which is a party to the New York Convention. So bear that in mind. Also, it's important to note that how much control will a court have over this arbitration. So there are some jurisdictions where courts often have excessive control on arbitration proceedings, right? So and you would if you don't want that, and if you don't want extra supervision or interference by the national courts in your arbitration, then you would want to choose a jurisdiction where such interference from national courts is less. Okay. Then we come to the third aspect, which is the governing law. Now, what is the governing law of a contract? The governing law of a contract is the law which decides your rights and obligations of the parties. So, whether or not you've breached a contract, so whether this in a contract between a sale of sugar between an Indian party and a Singaporean party, I have delivered sugar and I have not been paid. The other party is saying that the sugar was not of good quality. Now, which law will decide whether the sugar was or was not of good quality, or whether, I delivered it on time, or whether I didn't deliver the sugar on time? That is your governing law. So the governing law of your contract needs to be a a law that you would generally be familiar with, right? So in a contract between an Indian party and Singaporean party, don't put, say, laws of France will apply, because it's a civil law country. A Singaporean party and neither the Indian party would have a lot of information about this, so you don't want to be put in such position. If you want a neutral law, then choose any other common law jurisdiction. So you can choose London, for example, right? Because principles are fairly similar. So just for the sake of neutrality, don't choose a law which is absolutely something that you don't know of, and you don't want to be in a position where then you have to appoint local lawyers in that jurisdiction and you don't know anything about a civil law system. So avoid being in that position, right?
Chinmayee, one question.
Yes, sir.
Do we have these concepts in domestic arbitration? Or how does it differ in domestic arbitration?
Right. So in domestic arbitration, what you need to, a domestic arbitration is where if two Indian parties, right, choose, a sale of sugar. Now, if I'm in Bombay, somebody is in Delhi. I want to sell sugar to this party in Delhi sitting in Bombay. Now, what will I choose in my contract? What will my arbitration say? Can I choose a foreign seat? Well, I can choose whether it needs to be an ad hoc or an institution arbitration. So the first thing is the same, right? I can choose whether MCI can apply to this arbitration, right? The Mumbai Center for, or I can say that, I can have an ad hoc arbitration. The seat, whether do I need to have a seat in India compulsorily, or can I have a foreign seat? Can two Indian parties choose to have a seat in Singapore, for example, for this contract? Anybody has any idea? Do you think that can happen? Unmute yourself and say yes or no. That's perfectly fine. Anyone? Sorry, I can't see the chat box for some reason.
Yes, we can choose a foreign seat. Recently in the PSL wind judgment, it was held by the Supreme Court.
Perfect. Excellent. So there was a big question mark about whether two Indian parties can choose a foreign seat until recently. And then the Supreme Court has clarified to say that this can happen because of party autonomy, which is paramount. And two Indian parties can choose to have a seat outside India, right? Governing law. Now, this is still a tricky question because there is no full consensus on whether two Indian parties have to choose Indian law or whether they can choose a foreign law. The law as it stands right now, two Indian parties cannot choose to govern their dispute by any other law other than Indian law because of Section 28 of the Indian Contract Act, right? Now, this is differentiation between domestic and international arbitration. Now
No,
we
Chinmayee,
Yes, sir.
one query. Is there a concept of governing law under domestic arbitration? What would be a governing law in a domestic arbitration?
Well, you can say in a domestic arbitration, if parties were the arbitration clause can say that this generally there it would say that this contract is governed by Indian law. If they put it, generally they would say that courts of this jurisdiction, courts of Bombay will have jurisdiction, or courts of Bombay will have Delhi will have jurisdiction. But generally speaking, an domestic contract between Indian parties will not have a governing law, because the law generally says that two Indian parties cannot have a law which is foreign to them to govern their rights and obligations. So mostly the arbitration clause will be silent on this aspect. But if and when the Supreme Court clarifies the position, then the parties can choose to have a foreign law if at all that happens. But in an international arbitration, a governing law is definitely something that the parties need to consider and put in an arbitration agreement, right?
So in your opinion, in domestic arbitration clauses, basically, instead of governing law, there would be a law on jurisdiction of a particular court place.
Yes, yes,
Yeah.
yes.
Okay.
Yes.
All right.
In terms of law of the arbitration agreement, now what is this law? This is also very alien to domestic arbitration, because a thought doesn't really go into this, and a lot of, if it's just a simple domestic arrangement, then you don't, everything's basically governed by Indian law, right? Other than a foreign seat which you now can put. But what is this law of an arbitration agreement? What does it do? And a law of an arbitration agreement decides the scope and validity of the arbitration agreement itself. It also decides whether your dispute is arbitrable or not. Now, to give you an example, I was in a dispute before a Singaporean, before the SIC, so the Singapore International Arbitration Center. It was a dispute between an Indian party and a Singaporean party, and the governing law was Indian law of the dispute, and it was seated in Singapore. So the seat was Singapore, the institution rules were SIAC rules. One party was Indian, another party was Singaporean, and the governing law was Indian law. The dispute was on oppression and mismanagement. It was a shareholder dispute, and the the parties were alleging oppression and mismanagement of this company that they were shareholders of. The arbitration agreement did not was silent on what the law of the arbitration agreement was. So the question before the tribunal was whether the arbitration agreement contemplates what is the law of the arbitration agreement first, and whether that law then contemplates arbitrability of oppression and mismanagement disputes. Because if this law of arbitration agreement was to be held as Indian law, which was the governing law, then these disputes were not arbitrable at all, so the tribunal would not have been able to adjudicate on them. But if the law of the arbitration was held to be the law of the seat, which is Singaporean law, then under Singaporean law, these disputes were arbitrable, right? So it was very important. And since the agreement was silent, the first thing the tribunal had to determine was what was the law of the arbitration agreement. And then it said that the law of the seat was, if the agreement was silent, the tribunal held that the law of the seat would apply, and therefore it applied Singaporean law. And then it said that, this is arbitrable, so we have jurisdiction. But these are the problems that will arise if you don't put in the law of the arbitration agreement in your arbitration clause, because you don't know then what law, whether the law of the governing law or the seat would the tribunal apply, and whether it would be favorable to you or not. And I know it sounds very difficult to fathom, and you think of all of this once a dispute is arisen. You don't really think of it when you actually draft the contract at midnight, when you just say, it's a 5-line clause, arbitration hai, bus, that's all, that's all that is needed. But technically speaking, these are really truly like the core elements that every arbitration clause should actually have. Then we go to the number of arbitrators. It can be a sole arbitrator or it can be a tribunal. While you're actually choosing this, it is important to be conscious of what is your transaction amount, right? If it's a small value dispute, you don't want to have 3 arbitrators, because not only it would be a massive expense to have 3 arbitrators, it is also going to be difficult to have to get their diary together and get them to be at the same place on the same date for your disputes. Their availability becomes a problem. So if it's a simple transaction with relatively small value, choose a sole arbitrator. But if it's a complex dispute with high value dispute, dispute where you want to have the option to have your arbitrator and your nominee on the tribunal instead of just one sole arbitrator, then you choose a panel instead of a sole arbitrator. But think about this. I mean, the point that I'm trying to drive home here is think about all of those things before, while you're drafting your arbitration agreement, and not once the dispute has arisen, right? The last primary consideration that
Chinmayee, just one question here. Can you relate this issue of number of arbitrators with provision of Section 11 and
yes,
explain a little bit on that?
of course, sir. Do we all have our Bare Acts? So
I think
what
most
does
of them would be carrying it.
Yes, right. So what Section 11 does is, so if in case of an ad hoc arbitration, um, if there's a sole arbitrator, if your arbitration agreement says that your arbitration, the dispute would be adjudicated by a sole arbitrator appointed by both parties. Now, when a dispute arises, what the person who's aggrieved, he would do is he'll send a notice, right, under Section 11 to invoke your arbitration, and he will say, okay, I nominate so and so to be the sole arbitrator, give me consent. The other side is not going to agree, right? No matter, once a dispute is arisen, there is no chance that the other side will agree to anything that you say, because automatically they'll start thinking, oh, why he's chosen this person and not that person, then there must be some bias involved, so that person will not agree to whoever you choose. So in this situation, if it's an ad hoc arbitration, then the parties have to go to the court. So if it's a domestic arbitration, then you go to a high court, and the high court will then appoint an arbitrator for you. If it's an international commercial arbitration seated in India, then you have to go to the Supreme Court for nominating this. On the other side, if your arbitration agreement had said that, MCI rules apply or CIAC rules apply, then it's the institution who will choose the arbitrator for you. So you don't have to go to court for doing that. So they do it for you, right? There are certain acts where it says that in case the agreement is silent, then if the agreement doesn't provide for a number of arbitrators, then it would be one. I think the Indian Arbitration Act also says that. I'm sure Mr. Shah will correct me if I'm saying this wrong, but the Indian Arbitration Act
10. Go to Section 10.
That's exactly what I'm looking at. So what Section 10 says is that the parties are free to determine the number of arbitrators, provided that such number shall not be an even number. And failing determination referred to in subsection 1, the arbitral tribunal shall consist of a sole arbitrator. So if today your arbitration clause says nothing, then how do you determine what is going to be? So if your arbitration is seated in India, or if it's a domestic arbitration, then the Section 10 of the Arbitration Act will be triggered, and if your arbitration will be governed, adjudicated by a sole arbitrator. Similarly, if your arbitration was seated in Singapore, then the Singapore's International Arbitration Act, if it had a provision similar to the Indian Arbitration Act, that will apply, right? Because the law of the seat will govern your procedural aspects of the arbitration. Let's go to the language. Now, language is like the last thing you think about when you would want to put it. I mean, generally your language would be English, right? But this is what you think because we come from common law jurisdictions having studied in English, and English being our primary language that we use for all our communications. One thing to bear in mind though is whatever language of the arbitration you choose, ensure that it's consistent with the language of the contract. So if your contract is in Chinese, don't have your arbitration in English, right? Have your arbitration then also in Mandarin or whatever. Also ensure that the language of the arbitration is also the language of the correspondence that has happened between the parties. So that is very important. And linking this to your arbitrators, at least appoint one arbitrator who knows the language, right? So appointing an Indian arbitrator to adjudicate a dispute where a Chinese witness is being cross-examined, it's going to be inefficient because there will be an interpreter and then it will just go in a complete circle and that will not be really efficient. So think about these things when you're choosing the language of the arbitration. Consider, I mean, there's recently a fad about necessity of multilingual arbitration. So they say that, oh, the language of the arbitration is English and would be French, for example. But I mean, although it's all very well to have this, but it will just be more costly and often time consuming. Also, the arbitrator pool who would know both of these languages or it will also be very limited. So think about all of this when you choose this. Can we go to the next slide, please?
Chinmayee,
Yes.
before we go to that, can there be a issue of language in a domestic arbitration?
There can be an issue of language in a domestic arbitration as well. And I have, in fact, been in such an arbitration. So I was in an arbitration between, this was, I think, a development agreement. And the parties on the other side were only familiar with Gujarati and they were not very, adept at speaking in English. So when it came to cross-examination, all of the pleading, statement of claim, everything happened, in English because the lawyers drafted it, the lawyers must have explained. But when it came to cross-examination, that is when the real problem arose because since the arbitration's language was in English, my counsel asked the witness questions in English. Then because it was a domestic arbitration, there was nothing so fancy to have like a interpreter and whatnot for that arbitration. So one of the judges on the tribunal, so one of the arbitrators, he was familiar with the language. So the arbitrator translated the question to the witness. Then the witness answered in broken English, broken local language, and then the judge, the arbitrator, who was the chair in fact of the tribunal, it was a 3-member panel, he translated it into English, and then there was a steno who would basically type his answer in English. And that entire process sort of was time consuming, and secondly, it sort of just missed the point of having an effective cross-examination. I see Nikhil and Shivam have questions because I can see their hands are raised. Just feel free to unmute yourself and interrupt me anytime.
There is a question in the chat box. I think Shivam wanted to ask something. So I'm unmuting him.
Yeah, Shivam, just feel free to ask.
Yeah, good afternoon, ma'am.
Good afternoon.
I was just asking that whether there's a difference between governing law or law of arbitration agreement, because due to some technical glitch, I missed that part.
Yes, oh, no problem. So the governing law is the law which determines the rights and obligations of the parties to a transaction, whereas the arbitration agreement, the law of the arbitration agreement determines the scope and validity of the arbitration agreement itself. So whether or not your dispute is arbitrable will be governed by the law of the arbitration agreement, whereas whether or not you've breached a contract or whether you fulfill the terms and conditions of the contract will be governed by your governing law of the contract. Is that clear?
Chinmayee, just adding to what you mentioned, you see, you have to understand it in this simple way that as in the last session, it was mentioned by Mr. Arush, that arbitration agreement and the main contract are separable.
Yes.
Yeah. So if we go by that principle and that understanding, then, and that is where this difference of governing law and law of arbitration come into play. Meaning thereby, since they are two separate contracts altogether, the main contract and the agreement as such in itself a contract. Therefore, there are two contracts and therefore there can be two separate laws. So one law would govern the main contract and the other law would govern the arbitration agreement. And that's how you have to understand this in a very simple way. There's no confusion about it. Yeah. If you can understand the separability principle, then you will definitely understand these two aspects.
Absolutely. And just to add to that, about 95% of the times, nobody would have a separate law of the arbitration agreement in their contract unless they're really astute and they've applied their mind and they've put it separately. Most contracts will say that the arbitration is seated in X country and it would be governed by the law of the of Y country. It would never specify what the law of the arbitration agreement is. And then when the matter comes before an arbitrator and when a dispute is arisen, then you left in a position, if at all, where you have to decide the arbitrability of an issue, like it happened in my Singaporean arbitration, where we had to decide whether, issues of oppression and mismanagement were arbitrable. That is when the tribunal had to look at, oh, what is the law of the arbitration agreement, and they realized that there was none, and then they had to determine it based on the conduct of the parties and the language of the clause. And that is what you would want to avoid, and therefore it's always prudent to put in a law of the arbitration agreement itself for clarity from beforehand, right? So let's take
There's one pending question on somebody asking difference between ad hoc and institutional arbitration.
Oh, difference between ad hoc and institution. That's very simple. So an ad hoc arbitration is where, Shivani, I can see you on screen, so I'm going to take your name right now for this example. I hope that's okay. An ad hoc arbitration is where if Shivani and I enter into a dispute, entered into a transaction for sale of sugar. That's my favorite example to give everyone. Shivani and I will say that if there's a dispute between the two of us under this transaction, then it would be referred to arbitration, which would be governed by a sole arbitrator. Let's have one arbitrator for this example. And then when a dispute arises, the arbitration's invoked, I nominate an arbitrator. Shivani, for a change, agrees with me and say, okay, we will appoint Mr. Samir Shah as our arbitrator. Now, this arbitration that happens before Mr. Shah today is an ad hoc arbitration. Then Mr. Shah will decide what rules he wants to adopt for the arbitration. He would, in agreement with the parties, come up with the procedural requirements, of course, following the timeline set out in your Indian Arbitration Act, right? So this arbitration is a ad hoc arbitration, where Mr. Shah, as an arbitrator, will have liberty to decide his own process and rules and timelines and whatnot within the ambit of the Act. Now, if Shivani and I in the same contract say that our arbitration would be governed, by, there'll be a sole arbitrator, but it will be governed under the rules of the Mumbai Center for International Arbitration. Now, in this case, if I invoke what will this Mumbai Center for International Arbitration do for me? This institution does a lot of things. An institution will basically will have its own set of rules. So it will have a predetermined structure for my arbitration. So tomorrow, if I don't file my statement of claim in time, the institute will send me emails to say, oh, you breached your timeline or whatever. So it does the administrative job of keeping your arbitration on track, right? An appointment of Mr. Shah will also happen through an institution instead of through a court if Shivani and I don't agree on, who to appoint as an arbitrator. So the institution basically appoints arbitrators for you, takes charge of all of the administrative decisions that need to be taken, and it gives you administrative support in terms of rules and guidelines for the process of your arbitration. It obviously does it for a fee, and generally speaking, which is why most domestic Indian arbitrations are ad hoc arbitrations. They're not institution arbitrations, because institution arbitrations come with its own set of fees and charges, which are okay for big ticket contracts or big ticket transactions or international transactions, is what the general mindset of the parties is. So do you have anything more to add? Yes, ma'am.
No, please continue, Chinmayee. Thank you for that. Yes.
May I ask a question, ma'am?
Yes, please go ahead.
Ma'am, I just wanted to clarify that the matter of arbitrability of any dispute depends on the governing law or the law of arbitration agreement. For
Law of
instance,
the arbitration
for example, an agreement is inarbitrable in India, like it is a criminal matter, so, or any insolvency matter. So can it be made arbitrable by choosing a foreign seat? Won't it be against the public policy?
No, so you have to realize there are three sets of laws, right? Law of the seat, law of the governing law, and law of the arbitration agreement. Like Mr. Shah said, an there's a separate law for the arbitration agreement because it is a separable agreement, like Mr. Arush must have explained to you in the previous session. So, a foreign seat is something that two Indian parties can choose now, according to the Supreme Court. With a governing law of the main contract or a law of the arbitration agreement, as there's still not enough clarity on whether two Indians can choose a different law of arbitration agreement or a different law of governing law, which is other than the Indian law. Right now, Indians can't do it. So you can't choose a separate law of the arbitration agreement, and because you have to have Indian law and make something arbitrable, because that won't be right. Because the law of the seat cannot determine whether an issue is arbitrable or not. It would be the law of the arbitration agreement.
So just adding little more clarity to that. You see, when we say that the law of seat would become the governing law in that context, your question or your example of, let's say, insolvency issue or dispute on insolvency, it may not be arbitrable in India because of the current governing law of India. But if the seat is, let's say, Singapore or some other jurisdiction where it can be arbitrated, then definitely it can be arbitrated if the parties have chosen that seat, because that seat law at that point of time would come into play and it becomes arbitrable to that extent. Correct, Chinmayee?
Not the seat law, so it's only the law of the arbitration agreement can determine that. So if the law of the arbitration agreement was Singapore, it's only then would issues like insolvency may be arbitrable. Just because an arbitration is seated in Singapore, that does not make all of the issues that are not arbitrable under the law of the arbitration agreement would make it arbitrable.
Great. So that's the reason why I said like that, to remove this confusion.
Yes, great. Can we quickly move on to the next slide, because I want to show you an ideal clause. So after looking at all of these core elements and primary considerations, let's just look at a clause which sort of takes care of all of this, right? You need to click a couple of more times to have the perfect. So this is generally a model.
No. Just can you just remove this immediately, please? Remove this slide quickly. Yes. Oh, remove this slide, please. Yes. Okay. Now, please make it as if you are not seeing that slide and quickly draft a clause based on whatever talk you just heard right now. A quick 2 minutes to draft a clause as Chinmayee has explained. Let us see. And then we'll go to that slide and compare whether you are right or wrong. Correct? Let's do that 2 minutes from now. Yeah.
And somebody needs to be bold enough to show their arbitration clause to us. Okay, so not
Yes.
just do it,
Yes.
but also show it to us.
Those who are attempting at least can raise their hand so we can see that at least some you are doing it. Otherwise, we just looking at the blank screen. As said in the beginning, we're trying to make this interactive. We are not here to lecture you. Anyone attempting? Yes. Samnavi, is it correct? Have I pronounced it right? All right.
Yes, sir.
Please go ahead. Let's see what you have drafted. Let us hear.
Yes, I'm still writing. I'll just get back to you. Please give me 1 minute.
Take your time. Take your time.
Granted.
Yes, sir.
Samir sir is more difficult than I am generally about these things.
No, see, the purpose is actually to make them understand, I mean, what is the arbitration agreement, what is the importance, how you're going to draft. We have given them, I have given a brief outline with quite details on it. You have already, told them about the main features of it. Let's see whether they have actually understood till this stage what we have said. Yes, Samanvi, your time stops now.
So 1 minute, still 30 seconds.
Anybody else have anything ready? Nikhil, I can see you, so I'm picking on you. I'm sorry. Do you have anything?
Can I?
Out of 172 participants, only 2 people are bold enough to attempt this.
Do you guys want to put your arbitration clause in the chat box or say it out loud? You can choose what you want to do.
And I'm just putting in the chat box. Please, some more time.
So can I add in the meanwhile?
Yes, of course.
Yeah. So ma'am was telling about the difference between governing law and the law of the arbitration agreement. So I thought there's increased scope for confusion when we draft a vague arbitration clause without specifying the difference between the governing law and the law of the arbitration agreement. So the clause I drafted was notwithstanding the governing law of the contract, the arbitration shall be seated at London. So this was assuming, let's say, the governing law of the contract prescribes in Indian law to be the governing law. I was thinking the arbitration clause could say that notwithstanding the governing law of the contract, the arbitration shall be seated at London, which would, I assume, then make the laws applicable in London subject to the arbitration.
But just one question. I don't know who's speaking, but why you have used this non-S clause?
So I was thinking, I mean, like that makes it a step more clear in indicating the demarcation between the contract and the arbitration agreement.
Wouldn't it be just
But
easier
you see,
to say, sorry.
Yeah, Chinmayee, yeah, please go ahead.
I think the non-obstante clause just adds to complexity more than taking it away. You should just say the contract is governed by, Indian law. The law of the arbitration agreement is English law. I mean, simple. Why do you need to have, the notwithstanding the governing law statement? Yeah.
Yes, Samanvi, you have now enough time. Instead of typing out, why don't you just read out for the benefit of all?
Sir, I'll read out just last sentence.
Okay, sir. It's Shivam this side.
Yes. Yeah, Shivam.
I tried a bit, but I know it's not going to be correct.
That's fine. Just give it a go.
Okay. So here it goes that
why you are assuming beforehand?
Yeah. All dispute arises or will be arise in the future will be dealt according to the governing law of India. The seat of arbitration will be dealt according to the common law country between the party in dispute. The language of the arbitration will be party or autonomy will be decided accordingly during the dispute.
That's it?
Okay.
All right. Let us go back. Just try to recollect what I have said. If you read section 7, does your clause actually clarify the intention of the parties, what we known as the consensus ad idem, of referring a dispute to arbitration at all at the first place? It's talking about governing law, it's talking about the law of agreement, but where does it say that it will be referred to arbitration? Can you just repeat your clause again?
Also,
Sure.
how many arbitrators? Do you want sole arbitrator? Do you want 3 arbitrators?
Yeah, sir. I just briefed it very little that I just forgot the main heart of the main clause, that I forgot to write the arbitration agreement.
You see, if you forget the heart, then the life is out. Yeah. So never forget
Yes, sir.
the heart.
I really apologize.
No.
Okay, sure.
Please
I
don't
will listen the
apologize.
next meeting.
This is not an issue of apology. You see, you are actually, this is the exercise for you to learn. So no need to apologize. I mean, you are bound to make mistake. That's fine, and that's exactly is what this exercise is all about, to make you understand what are the mistakes, what are the consequences of this mistake, so that you can then understand the effective of an arbitration clause. What would be a proper arbitration clause? Yeah. So no need to apology for that. Yes.
Okay, I jot down every point, and from the next time I'll do my best.
Great. Thank you. That's great. Samanvi, now I think we are eager to hear you.
Yes, sir. So, any difference or dispute arising out of or in relation to this contract shall be referred to whichever the rules the parties are agreeing to. The governing law for this contract will be law of India, or whichever the parties decide. Dash would be the seat of the arbitration, and the number of arbitrators shall be dash as the parties would agree, or they decide that at the time of dispute we'll decide again. The arbitration shall be carried in Hindi or English language, whichever is comfortable with the parties, or as agreed by the parties then.
I think you were very quick to cut, copy, paste the slide, which took some time to remove. Huh? Samanvi?
So
Yeah?
definitely not, sir. So these are all the points that I noted. There were pointers in the slide.
No, please. It was just on a lighter tone, but that's an excellent attempt, definitely. Very nicely done. Now, Chinmayee would tell you about that.
So,
yes, Chinmayee.
So actually there is one more individual, Mr. Bhavesh, Advocate Bhavesh Tiwari.
Before we
we'll come to that. We'll come to that. Yeah.
Yeah, what was wrong with
let's
okay.
Chinmayee, please continue.
Right. Okay. So I think you did a really good attempt in terms of drafting your arbitration agreement. The one problem that I immediately picked up was you've said that, the language would be Indian English, or as the parties would agree once the dispute is arisen. And this was not just for the language, but for a couple of other elements too. You have to bear in mind that parties are not going to agree to anything once the dispute is arisen, right? So it's very important that you put it down in the agreement and not leave anything to the future, because you don't know how the relationship is going to be between the parties once a dispute arises, right? So if you want to say the language is going to be Hindi or English, leave it at that. Don't say what the parties would agree to, or even in terms of the law or the governing law of the contract, right? Just say that the governing law is in Indian law. Don't say or something that the parties will agree to. So that is one of the main problems that I thought was with the clause. Also, you skipped on the law of the arbitration agreement, which we've been trying to stress upon, that you should
Yes,
really
yes,
try and put it into your clause.
I didn't want to borrow 10 or 30 more seconds to write. That's why I said that I'll just quickly put that in the chat.
That's fine.
But definitely, it was a very nice attempt given the such short timelines. Because you see, this clause drafting takes hell of a lot of time. Much of the brainstorming goes into drafting a valid arbitration clause because of the various issues which Chinmayee just presented before you, and the consequences that can arise from those issues. So a good attempt definitely on your part. Yes, Mr. Bhavsar is there. Bhavsar is, yeah, Bhavesh, sorry.
Yes, good evening,
Yes,
sir. Actually, I
yeah,
have
good
sent
evening.
draft in the message as well.
Okay,
If you may
let
allow, I
me
can
just
read.
check. Hold on.
So may I read?
Yeah,
to you?
please.
Yes, sir. It is hereby agreed to by the parties that any dispute whatsoever arising out of or in connection to this agreement shall be resolved through arbitration by a sole arbitrator. The seat and venue of the arbitration shall be in Indore, Madhya Pradesh. The language of arbitration shall be English, and the arbitral proceeding shall be governed by the Indian laws. The appointment of arbitrator shall be made by MCIA on application by the either party.
Yes.
Okay.
Chinmayee, what would happen?
Right. What do you, so should we ask Mr. Tiwari, what do you think may have gone wrong with this?
Maybe the appointment of arbitrator and the law governing this agreement.
Well, there are two things that I immediately picked up. First is you said that the seat and the venue would be Indore, Madhya Pradesh. You don't need to specify where the venue is. And if you are specifying where the venue is, then you're actually binding the parties to go all the way to Indore, Madhya Pradesh to have this every hearing in that arbitration, right? So if you specify the venue, then the parties are bound by that venue, firstly. So you can leave that out. I mean, so long as the juridical seat is Indore, Madhya Pradesh, that's enough for the purposes of the clause, because that leaves room for you to hold hearings virtually. That leaves room for you to hold hearings in Delhi or Mumbai or Pune if you want to, right? So that's one thing. Now, the parties saying that in case of not agreement, the MCIA will appoint an arbitrator. Now, the problem with that is two things. You're giving MCIA only the power to appoint an arbitrator, and you're not adopting MCIA rules to the entire procedure. While this can be done, sometimes in international arbitration clauses where you will give one person to appoint the authority to appoint your arbitrator. For example, the president of the Chartered Institute of Arbitrators will appoint the nominate the arbitrator if the parties don't agree or something. But generally in Indian arbitrations, in this case, if the act is very clear, right? In case the parties don't agree, then they have to go to court to appoint. So you don't want to sort of be in a position where the parties fight about this at the stage of nominating an arbitrator itself, whether MCI's nomination was valid or not valid given the provisions of the act itself. So that is one thing I thought was problematic. Mr. Shah, do you have anything else to add?
Yes. You see, you correctly pointed out the main issue would happen in appointment, because it says first that the parties would refer it to a sole arbitrator, correct? And then it also says that the appointment shall be made by MCIA on the application by either of the parties. So just recollect what I've said. Don't use these open-ended words, or don't give these many options to the parties. You see, you have to understand that when two person, I mean, visualize in a general scenario. Take your, or in a general life, when you are in dispute with someone, You tend to disagree to each and everything what the other person is saying. Yeah, that's a normal behavior, normal human behavior. And that's exactly what happens in case of a commercial dispute also. So here what will happen, once the parties are in dispute, then they would disagree to each and everything what the other side is saying, no matter whether it is relevant or irrelevant. Generally speaking, the respondent, the opposite party, in this case, in order to counter the claimant to have its choice of arbitrator, would make an application to MCIA just for two purposes. One, just to ensure that the arbitrator is not of the choice of that claimant, and also to delay. Because you see, there will be a process where you have to approach MCA. MCA will take some time to do that. Yeah. And then that can again be disputed. So why unnecessarily give? You see, the purpose of an arbitration agreement is to avoid these kind of dispute on that dispute clause itself. That's what I said. That's what this second slide, what Chinmayee showed. It tells the reality of the situation. Majority of the dispute in court happens on the dispute resolution clause itself. The parties are forgetting their main dispute and unnecessarily wasting time and cost, either in court proceedings or exchange of their communications. Why you do that? So that is the purpose. When you are, that is the purpose, how and why you should be covering all these important aspects, what Chinmayee told you about. And now let's go to a model clause, which will help you understand where you were going wrong in your drafting. So yes, now to that model clause, please. Chinmayee.
Yes. Yes.
So what does it say? Any dispute arising out of or in connection with this contract, including any questions regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration in accordance with the arbitration rules of, if you want to put an institution, then you say the rules of the Mumbai Center for International Arbitration or the arbitration rules of the London Court of International Arbitration, right? Which rules are deemed to be incorporated by reference in this clause. If you want to have an ad hoc arbitration, just remove everything after arbitration rules, just the words arbitration rules, and which rules will be deemed to be incorporated, and just leave it at resolved by arbitration, full stop, right? If it's an ad hoc arbitration. But if you want an institution arbitration, then use the rest of the line. Then you come to all of the other points and see how clearly and nicely it is drafted, right? The seat of the arbitration shall be so and so. The tribunal shall consist of 1 or 3 arbitrators. The language of the arbitration shall be so and so. The law governing the arbitration agreement shall be so and so. And the law governing the contract shall be so and so. Right? So there's no confusion. There's full clarity on what the parties have chosen each law to be and what their intention is. Now, one trick, and that is something that I learned from Mr. Shah a couple of years ago, is that if you want to, if you've decided that you want an institution arbitration, you don't want an ad hoc arbitration, go to that website of that institution. All of these main institutions have their rules and have their own model clause. So if you've decided you want your arbitration to be governed by the ICC rules or the SIAC rules or the MCI rules, go to the website, pick up those rules, put it in, use those as your model rules, and then play around with the language, the law of the governing agreement, the law of the governing clause of the contract and the seat, right? So those you pick, but the language, just lift it from those institution rules and put it in. So half your battle is won then and there, right? Great. Okay. So far, and I am conscious of the time that we only have 15 minutes and there's a lot to cover. So I'm going to brush through the next bits a little quickly. what we've studied so far is absolute basics. Like these are the core elements that must be there in a clause, no matter what. What are the other things that you can add to it? I know you're complicating this further, but at the same time, there are sometimes transactions which need those complications. So, for example, what more can you provide, right? As Mr. Shah said, why just say that, dispute will go straight to arbitration? Why not have a multi-tiered clause, which he advocated for, and say that, first let, parties try and negotiate the dispute for, say, 30 days. And then if that negotiation fails, then the parties will go to an arbitration, or then the parties will try to mediate. And then if mediation fails, then the parties will go to an arbitration. So that is something called as a multi-tiered clause. If you can go to the next slide, please.
Yes, ma'am.
So these are the optional considerations that I've set out for you here. So first is having multi-tiered alternate dispute resolution clauses. What you need to be conscious about in multi-tiered dispute resolution clauses is to have a clear trigger point on when to move from one dispute resolution mechanism to another. So don't just say that, parties will negotiate in good faith, like Mr. Shamir Shah pointed out, and then parties will arbitrate. When will they do it? What is reasonable? What is good faith? Don't leave all of that for, the arbitrators to determine later on once the dispute is arisen. So in case of multi-tier dispute resolution clause, have specific trigger points. So the parties will try to negotiate the dispute for 30 days. Failing negotiations, the matter will go to arbitration. So provide clear trigger points. Provide whether or not each of these alternate dispute resolution mechanisms that you've put in a clause, whether they're mandatory or optional. Because problems also arise when parties say, oh, it was not mandated to negotiate. What the clause said is that, oh, parties may negotiate, not parties shall negotiate. So picking up from what Mr. Shah said, the use of word shall and may is also very important in terms of how you draft it, right? Now, coming to the second point, multi-party, multi-contract clauses. Now, this model clause that I've shown you may or may not apply to contracts which have like multiple parties. So if it's like a 4-party contract, then which party has an option to choose an arbitrator? Can all parties, if there are 4 parties, can 4 parties choose like one arbitrator? Can that be done? No, because then you have to have odd numbers, and mostly you have a sole arbitrator or a 3-member panel. Then who has a right to nominate, who doesn't have a right to nominate an arbitrator? So all of those considerations you might want to put into your arbitration clause beforehand, so that there is no dispute later on about all of this. And in case of multi-party arbitrations, just provide for joinder of parties, or provide for mechanisms that 2 parties are considered as like one part for appointing an arbitrator, or so on and so forth. The safer solution, instead of doing all of this, is to provide for an appointing authority to nominate and appoint a tribunal for you guys. So if it's like a 5-party arbitration agreement, instead of saying each party does it, or 3 parties can do it and 2 parties cannot, and 2 parties will be considered as 1 party for the purpose of nomination, just say that all parties agree that MCI will nominate the tribunal for them. So that's another way to take a look at it. Then you also have something called as multi-contract clauses. So there would be multiple agreements entered into between the same parties, right? How do you deal with such situations? Ensure that all of these agreements have like the same dispute resolution clause. Because if one agreement between them has an arbitration clause and another says, courts of Bombay will have jurisdiction, then technically speaking, there would be parallel proceedings and it will just be a mayhem, and you would want to avoid that. So if there are multiple contracts for the same transaction between the same parties, try and ensure either there is an umbrella arbitration clause which applies to all of the contracts by reference, or have the same clause literally in all of the agreements. So that would just avoid more confusion, and it would be cost efficient also for the parties once a dispute arises. The third thing is confidentiality. A lot of countries now, including India, says that all arbitration under legislation must be confidential. But there are some countries that don't provide for confidentiality under their legislation. So if your transaction is such that you want to ensure that there's confidentiality maintained, then add a line to your clause to say that all arbitration proceedings and documents filed in the arbitration would be confidential, or something of that lines, right? Because you want to ensure, so for IP disputes in particular, you want to have that clause embedded in your agreement if the law of the seat of your agreement does not provide for confidentiality either by implication or by legislation like India does. So that's one thing. The fourth thing, qualifications of an arbitrator. You might want to put that, I would want my arbitrator to be a cement expert for a construction dispute, or you might want to say I would want to have an arbitrator with at least 15 to 20 years of experience, or something like that. Or you would want to have an insurance expert. And you can put it in because of the flexibility. Arbitration gives you a choice to choose who your arbitrators are. Flexibility and expertise is one of the benefits of arbitrations, and you might want to take advantage of it. But be careful of what you write in your clause, and then be also careful that you follow it through to the end. So for example, in one of the matters that I did, the arbitration clause provided that the arbitrator shall be a cement expert. And then the arbitration happened. It was a SIAC arbitration. The arbitration happened and award was passed. It came up for challenge, and the arbitrator who was appointed by SIAC was the SIAC arbitration seated in London, sorry. So, but in either case, the tribunal who was appointed the sole arbitrator, he was just a QC, like a Queen's Counsel, a barrister in England. He was not a cement expert. So we were successfully able to resist and challenge their arbitration award based on the fact that the arbitrator's appointment was not in accordance with the terms agreed between the parties, because he was not a cement expert. So think about this. So if you do put in qualifications of an arbitration in your clause, then follow it through to the end and ensure that the arbitrator follows that particular set of qualifications that you've put into your clause. Other things that you can put in terms of arbitrators is nationality. You can say that the arbitrator can be of a certain nationality if you want to. Then you can add in time limits or cost and fees. So you can say that the award will be passed within 1 year or 1.5 years, or once the arbitration's invoked, or a year after the pleadings are complete. Because like Mr. Shah said, not all jurisdictions provide for timelines like the Indian Arbitration Act does. So if your arbitration is not seated in India, and if it's seated abroad, and those laws don't have a specific timeline for making an award, then it may be useful for you to just sort of put in time limits if you want to have your arbitration being completed in a certain timeline. You can add, costs would be paid only by one party, or the losing party would pay for the costs of the other party. You can put in the fees that you would want the arbitrator to charge, or who will pay the fees in the first instance, or whatever. So you can put all of these, but these are all optional considerations that you would want to put in. They're not mandatory. The core things that have to go into your arbitration clause is the ones that we discussed before. But these are things you might want to bear in mind depending on what suits your transaction the best. Right? So the next slide is where I'll be showing you a model multi-tiered arbitration clause, which provides for negotiation, mediation, and then arbitration. So let's just take a look at it so that you guys understand, if you were ever to provide for a multi-tiered dispute resolution clause, then how it would look like generally. Can I have the next slide, please? So this is the clause recommended by the IBA, which is the International Bar Association. I'm sorry for the font of this, but it. Can anybody read this out for me? Can anyone volunteer?
No, Chinmayee, I think because of the time constraint, let it be there, and you can just refer to the main parts of it. There's no need to, let it be there so that they can read, and you can just explain the main part of it.
Sure. So what it says is basically, as you can see, it provides for a 3-layer dispute resolution mechanism. It first says that parties shall endeavor to resolve the dispute through negotiations, through at a higher level of management persons with direct responsibility. So it is very clear, right? As in, even if you're negotiating, who in your organization will negotiate this matter? Then it comes to the next step. It says mediation. So any dispute not resolved by negotiation within 30 days. So that is very important. It doesn't leave it open to say, because then parties would say, oh, we're still negotiating, you know, mediation has not been triggered yet. Then they can be negotiating for 2 years for all you know. So it needs to have a trigger point, and this within 30 days is a trigger point here. So if dispute is not resolved by negotiation in 30 days, then parties can request for a mediation. And then the third step comes that any dispute that is not resolved by mediation, as per paragraph B, within 45 days after the appointment of the mediator, or within such other period as the parties may agree in writing. So the clause does give an opportunity for parties to sort of extend this period if they do agree later on, because if the mediation is still ongoing after 45 days and there is a chance of settlement, then it allows the parties to extend this period by agreeing mutually. And then it says shall be finally settled by, you know, a designated set of arbitration rules by 1 or 3 arbitrators appointed in accordance with the rules. The place of arbitration shall be so and so, and the language of the arbitration shall be so and so. And where they say place here in this clause, just read it as seat, because seat is equated as place mostly in international agreements, in international context. What we know as the seat, which is the law of the procedure, sometimes they replace it by place. So just bear that in mind. So what we have for you after this, I know we just have 5 minutes. So I have made a couple of badly drafted arbitration clauses for you to sort of pick what is actually wrong with these clauses, right? So let's just go through them very quickly. And what I would like to do is just unmute yourself and just tell me what is wrong with it. And once one of you have gotten the right answer, we'll just move on to the next. Okay? Shall we have the next slide?
Yes, ma'am.
Okay. Can anybody tell me what's wrong with this clause? There are a couple of things wrong with the clause. So just shout out what the first thing that you notice.
Amicably, not settle with amicably.
Ma'am, the undue delay is not defined.
Sure, okay,
Without
undue
undue
delay.
delay.
That's fine. Does anybody have a problem
And with
with
the third country under the rule.
exactly, which is this third country?
Yeah.
I mean, it can be anything, right? In accordance with the rules of Bombay International Commercial Arbitration Association, is there an institution like this? Not that I know of, right? So, I mean, that is also wrong. Like Mr. Shah had initially pointed out, don't put in institutions or things that are not in existence. Or for example, you know, if you put in a name of an arbitrator, shall, for example, it would be you know, would be arbitrated by Mr. So and so. What if dispute arises 10 years later and this Mr. So and so is no longer, you know, living? I mean, I'm sorry to say that, but what if he's no longer there, or maybe doesn't do that kind of practice, or if he's not available? Then what happens to your clause? So avoid these things, right? Let's take the next example. Okay, what's wrong with this? I can pick 2 things myself. Anyone?
Ma'am, I think there is no such place like International Chamber of Commerce which have rules about arbitration, I think.
Ma'am, the institution is SCAC and the institutional rules is of ICC.
Correct. So now which of these would apply, right? So that's one glaring error. The second glaring error is all an any and all such disputes shall be resolved by negotiation or else finally by arbitration. Are you making negotiation
मैम
compulsory?
मीडिएशन मैम मीडिएशन भी इसमें पॉइंट आ सकता था ना?
Mediation, well, I mean, you could have put in mediation if you wanted to, but what is wrong with this agreement is that it doesn't say that the parties have to compulsorily negotiate. You don't know whether negotiation is mandated or not. For how many days do the parties have to negotiate? And it's only if negotiation fails, then can the parties go to arbitration, right? So all of these, so if you remember the previous model clause that we read, it gave clarity on trigger points on when one thing would end and when the other thing would begin, which this clause doesn't do, right?
मैम वन सिंपल क्वेश्चन में आई आस्क
Yes, please.
मैम माय क्वेश्चन इज दैट कि जैसे एग्रीमेंट अपन अमेंड कर रहे हैं तो जो आर्बिट्रेशन क्लॉज है वो भी अमेंड हो सकता है ना? मतलब जैसे कोई पर्सन है, हमने सूट हम दोनों ने प्लेस आर्बिट्रेशन किया दिल्ली में, एग्रीमेंट हम दोनों ने दिल्ली में किया, क्लॉज भी उसमें, प्लेस भी, वेन्यू सब डिसाइड किया कि दिल्ली में हम वो करेंगे, बट आई एम दैट टाइम जब एग्रीमेंट ब्रीच हो गया तो आई एम इन द प्लेस ऑफ न्यूयॉर्क at that time I am in the New York, then what happen in that case means the arbiter जो जिस पर दो पर्सन में और कॉन्ट्रैक्ट हुआ था वो दूसरा पर्सन यहाँ किसी और को अपॉइंट कर सकता है उस केस को सॉल्व आउट करने के लिए खुद की जगह?
So I think there are multiple questions आप पूछ रहे हो.
No, let me
yes,
try to answer this, Chinmayee. You see, first of all, understand there cannot be any unilateral amendments to the agreement, much less in an arbitration agreement. So आपके केस में जो आपने अभी एग्जांपल दिया, उसमें आप अगर यूरोप में हैं तो आप यूनिलेटरली प्लेस चेंज नहीं कर सकते हैं. पहली बात. सबसे जरूरी बात यह है कि आप जो भी कुछ करेंगे वो दोनों पार्टी के कंसेंट से ही होगी. आप यूनिलेटरली कोई भी पार्टी कोई चेंज नहीं कर सकती है. अब बताइए आगे क्या कंफ्यूजन है इसमें? I think who asked this? किसने पूछा था?
So Mr. Bhavesh.
Yes.
It was Subir.
Bhavesh.
Hello.
Okay.
So
Subir asked that question.
Mr. Subir.
Yes sir, doubt is cleared.
Correct? Okay.
Yes sir.
Great.
Okay.
Should we go to the next practice?
Yes, Mr. Bhavesh. Let him also, he has raised his hand. Yes, boliye, Mr. Bhavesh.
Yes, sir. In the present example, is it not possible that the arbitration can be conducted by CX, but the rules will be applicable of ICC?
No, because when you say conduct of arbitration, arbitration is always conducted by the tribunal that has been formed, and the rules that they'll apply is the rules that you choose of the institution, right? So if the arbitration can either be conducted by rules of SIC or they can be conducted by rules of ICC, they can't be, both of them can't apply together to an arbitration.
See, there is another aspect to this. You see, Singapore has presence of both SIAC and ICC as well. Okay. So therefore, there will be more confusion, as Chinmayee said, which rule of which institution would apply. There will be, a sort of dispute on this applicability of rules. And therefore, the matter anyway will have to go before the Singapore court because the place is Singapore.
Correct.
So then the court would decide. Obviously, court has to decide. But the point is not that. The point is why the parties want a court to come in when they've already chosen to go out of the court. That's what I said. So this is the issue which has to be avoided while drafting. Correct? Yes, Chinmayee, please.
Okay, let's go to the third one. Oh, I think this is same as the first one. Let's go to the fourth. Just click one more time. This one's slightly complicated, but the reason I've put it in is because this was a real agreement that came up before the English court, and which is now a landmark judgment on this point. It's called Sula America. But what I'm trying to say is that this is what happens when you don't draft your agreements properly, and if there is a confusion, so then ultimately the courts have to take a decision on what the parties actually intended at the time of entering into the contract, which sort of takes away everything from what the dispute is actually about. So in this clause, there are two clauses within the contract, right? One is the law and jurisdiction, and the second is arbitration. Can you tell me what is wrong with this clause? Anybody? Anyone? It's very simple and it's very glaring.
Ma'am, maybe the seat is decided to be in London, then the jurisdiction will transfer to the London court. Maybe this can be the thing.
Correct, one thing. The most glaring thing is clause 7 says that any dispute will go to courts of Brazil, and clause 12 says or any dispute will be arbitrated, which is what the parties have chosen. Do you want to go to court or do you want to go to arbitration? And if you are going to arbitration, then they've said that the seat of the arbitration is London, England, which means courts of England will have supervisory jurisdiction, and that is where your award will be challenged, and those courts will sort of make orders to give you interim reliefs in aid of your arbitration. Then how do you sort of marry that with the exclusive jurisdiction of the courts of Brazil, right? So that is what the court was faced with in this matter. Chalo, next example, because we're running out of time. Okay, this one's my favorite.
Ma'am, I was having a doubt.
Sure, please.
In the previous slide, so isn't it the meaning, like, can't we infer that the latter clause kind of is specific about one kind of dispute alone when it's a dispute with respect to the amount alone, whereas the form clause is a general.
Why not? I mean, so that is the problem, right? If any clause leaves room for interpretation, which means that one party will definitely take advantage of this and try and drag on the dispute once it arises. Because in any dispute, one party does not want the dispute to go on, right? They would always try and create hurdles. And you don't want to be in a position where you're left interpreting what the parties actually intended to say when they signed the contract. And that is the point we're all trying to drive home here today.
Thanks.
Okay, very quickly, example 5, because this connects to, I'll give you a tip so that you can tell me what's wrong. This is relevant to a recent Supreme Court judgment, which was passed about a year ago. And this is fully India-centric. Everything's happening in India in this clause.
And each and every line has an issue.
Yes.
May I?
Each line has a problem.
First and foremost, the time limit has not been given that if the party fails by mutual consultation in how much amount of time, and then the arbitration would come in picture. And I think the
Ma'am, it is also not mentioned that whether they are talking about negotiation or mediation in the first line, that settle between amicably between the mutual consultation.
I mean, you can infer mutual consultation as negotiations. There's not much.
I think the main problem arises with respect to dispute may be referred to arbitration instead of, like, it does not make it obligatory there. So in the presence of an absence of proper time limit given for mutual consultations, plus you're making the arbitrations are also discretionary. So then there's a whole lot of confusion as to when the dispute will come to an end.
I think
And the
Rupanshi,
decision of arbitration is
Rupanshi,
based upon a single person, that is only the seller. That at the election of the seller, the dispute may be referred.
Rupanshi has a very interesting observation. Rupanshi, can you just speak out loud, please?
Sir, I don't know if
Rupanshi,
I'm
are you
correct
there?
or wrong. Yes, sir, I'm here.
No, just what?
Sir, I don't know if I'm correct or not, but I just saw the first line and I got confused if it's talking about a claim or a dispute to be resolved. So
That's a very good point.
Exactly. You are very right, Rupanshi. It's a correct observation. So don't.
okay, sir.
As I told earlier, also to another colleague of yours, this exercise is not for you to say that you are mistake, you are wrong. It's good that you are wrong, then only you will learn what is right. But you are right. I would say, I am saying you are right. Yes, anyone else? What else?
Sir, I have a small question. In previous, ma'am said that in IBA recommended clause, there is a thing that first negotiation, mediation, then arbitration. But I think in this, mutual consultation means negotiation only, I think, because there is no third party involved in this. And after this, this is directly said that arbitration proceedings will be held. So I think I may be wrong, but should mutual
No,
consultation?
you are not wrong. Please, I am again saying, don't assume yourself to be wrong. Please.
Oh, okay, sir. Sorry, sir.
Your observation are right. Whosoever, I'm sorry, I couldn't. I'm unable to see the name, but you are right. Mutual consultation means negotiation because there is no third party involved, unlike in mediation. You're right.
Correct. But you also have to bear in mind that just because the model clause that I showed you of the IBA has negotiation, mediation, and arbitration, not necessarily that parties have to go through all of these levels to get to arbitration. They can just bypass negotiation completely and say parties will try to mediate and then arbitrate, or they can bypass mediation completely and say that parties will negotiate and then arbitrate. So it's not a hard and fast rule. So bear that in mind. We've just shown you so that these the alternatives available to you if you ever want to have a multi-tiered arbitration dispute resolution clause.
Understood. Thank you.
Okay, so
I think
the reason
let's go.
Yeah, so the reason why I had chosen this as the last example is because it sort of connects very nicely to the last point that I wanted to discuss with you guys, is some of the recent judgments that have been passed by the Supreme Court of India which are relevant to drafting arbitration agreement. The first one that I want to discuss is Perkins, and Perkins has been referred to by multiple Bombay High Court, Delhi High Court, Calcutta High Court judgments. But the first judgment of Perkins is when in 2019 the Supreme Court clarified that one party cannot unilaterally appoint an arbitrator. So even if your clause says that the seller at his option will be able to appoint an arbitrator, by virtue of this judgment, that's no longer possible despite your arbitration agreement allowing it, right? So there can be no unilateral appointment of an arbitrator going forward if an arbitration is seated in India and it's governed by Indian law, right? So that's the Perkins judgment. That's the first thing I wanted to point out. The second judgment that I wanted to refer to is something that we've already discussed. It's the GE Power PSL Wind Solutions, where two Indian parties can choose a foreign seat, which came out very recently, a couple of months ago. And one of you actually pointed this out when we were discussing whether two Indians can choose a foreign seat as one of the core elements of the contract. This was in question until very recently, but the Supreme Court has clarified this on the basis of party autonomy. And the third judgment that I wanted to talk to you about is slightly technical. It's NN Global versus Indo Unique flame. And that ties in very nice with the argument of separability of an arbitration agreement. And the reason why I put this in is because in this case, the main contract between the parties was not stamped, or it was insufficiently stamped. And in under Indian stamp laws, revenue laws, you know that if an agreement is insufficiently stamped, or if it's unstamped, that it cannot be accepted as evidence into your trial. But it's not a valid agreement until such time as you've paid your stamp duty on it. But what the Supreme Court said is that an arbitration agreement is a separate agreement from your main contract because of virtue of the separability of an arbitration agreement. And this arbitration, so even if the main contract is not stamped, the arbitration agreement still remains valid, because an arbitration agreement by itself does not need to be stamped. So even if the main contract cannot be admitted into evidence, or whether the main contract becomes invalid or is until such time as your stamp duty is paid, it has no bearing on the arbitration agreement itself. So that's all I wanted to discuss today with you guys. If you have any further questions before we close, please feel free to ask.
Chinmayee, just one addition to the last judgment.
Oh yes.
You see this matter. I mean, the NN Global one.
Mm-hmm.
This matter is sub judice before a larger bench of Supreme Court,
Yes.
which will now decide finally the issue
Yes.
of validity of an unstamped arbitration agreement.
Correct. Because there were conflicting views of the Supreme Court itself, which is why it's been referred to now a larger.
Yeah.
And we also have the Balasore Allies judgment here, which I'd forgotten I'd put in. This basically was, it's a High Court judgment. I don't think it's a Supreme Court judgment, but this basically dealt with if there are multiple contracts between the same parties for the same transactions, and they all have like different arbitration clauses, then which of them would apply? And then the court said it would depend on how the arbitration clause is invoked, and whether if it's invoked in the proper way, then the first arbitration clause and the first agreement that's been invoked sort of would apply, and not the other ones. But this is in that sense a very fact specific judgment, but it's useful to read it only to understand what difficulties can arise in case of multi-contract situations for the same transaction between the parties, and what issues can arise if you don't sort of set it out, at least have a common arbitration agreement, or have like an umbrella agreement which sort of incorporates by reference into other agreements. So if you, just one thing to bear in mind, don't have separate dispute resolution clauses between the same parties for the same transactions. And with that, I think I'd like to close for the day and thank everyone for being so patient with me and Sameer sir.
No, thanks to you, Chinmayee. I mean, thanks for taking that floor with such active and interesting presentation and talk on various aspects of arbitration agreement. I'm sure, in spite of the fact that majority of the participants were on mute, but they were actually listening, at least not hearing, because they need to also understand the difference between listening and hearing. But I'm sure that they would be listening to understand what we have talked about, and this will at least help them if they have just about to start on the subject, or even if they have already gone through, to brush up their knowledge. So thank you all the participants for patiently listening to us, and thank you of course to Pankaj sir for giving us this opportunity to share our knowledge and experience on this particular aspect of arbitration. Thank you so much. Thank you, Chinmayee, for supporting and helping this.
Always a pleasure. It's great being here.
Thank you so much, sir. Thank you so much, sir and ma'am. It was really a wonderful and great session for us. And I believe that all queries of our participants are resolved. And it was a really a great interactive session for us. And now we have come to an end of this lively gathering. It has been my pleasure to moderate the session.
I think,
yes, sir. Yes,
Nikhil, there is just one last question by Mr. Bhavesh Tiwari.
Yes, sir. Yes, sir. Please, sir. Yes, Mr. Bhavesh.
Yes.
If there is any dispute regarding the title of a property, can this be arbitrable? Or if it is arbitrable, then will the arbitral award need to be registered as per the Registration Act?
Can you repeat that again, please?
Yes, sir. If there is dispute regarding the title of a property between the parties and they are deciding to go for arbitration, will it be possible for them to go for arbitration? What I mean to say is that whether it is arbitrable or not. And if it is arbitrable, then whether the arbitral award deciding the title of the property should be registered as per the Registration Act.
I think the second part of your question answers your first. Are you able to understand why I'm saying this?
Yes,
and that
sir.
actually goes to the root question of what Chinmayee explained to you about the arbitrability of dispute. Though it's a subject in itself to understand that particular issue. But in brief, if I just want to answer your question, you see, in India and in many other jurisdictions also, not all disputes are arbitrable. And just understand a general principle, and the principle is those disputes which affects the public in general, which in legal language we call rightem rem, they are not arbitrable. Only those disputes which are inter se between the parties, which is what we say in legal jargon, right in persona, they are arbitrable. Now, in your case, you see, so far as India is concerned, and assuming that this issue, what you just mentioned, is in Indian context, we have a substantive central law which is called Transfer of Property Act. Yeah. Now, that act, you see, is applicable on the properties what is there in India. And therefore, when we are talking of a title of the property, you are basically going into the dispute of ownership, and which certainly has an element of public as such. And let me give an example. You see, that property may have been mortgaged. Yeah, you don't know, because when you're talking of a title, I hope you being a lawyer yourself, I mean, you would be able to understand. But for the students, I mean, it's a different topic altogether. But it's a part of the process of what we call the due diligence in legal terms. So when we are talking of a title of the property, you have to ascertain the ownership, and therefore you have to go back to the history of how that title of that property or the ownership rights of that property has transferred over a period of time. So where now in this definitely will have elements of in rem issues, as I give you an example of a mortgage. And therefore, to understand this, please read the judgment of Booz and Allen, the famous landmark judgment, which will help you understand this issue. And I'm sure Mr. Bhavesh would have read that. And if not, then I would also suggest to him to read that judgment of Booz and Allen, which is the landmark judgment. Just Google out and you will get that. There's no need of a citation. It's a very, very landmark judgment on this particular aspect of arbitrability by Supreme Court of India. So therefore, in your case, the answer, in my opinion, is no. Chinmayee, do you have anything else to add?
One thing to add, it may also be useful to read the Vidya Julia judgment that refers to Booz Allen, which came out of Supreme Court only back in late 2020. I think that judgment is extremely useful for all law students and all lawyers to understand what really arbitrability is all about. And it traces the history of the law of arbitrability in India and sets out what is arbitrable and what is not arbitrable, and how do you decide that in terms of what the Supreme Court has set down. So I think it would be useful if you read that judgment. And in any case, an arbitration agreement needs a domestic arbitration award needs to be stamped, but it need not be registered. So to answer your second question, generally.
No,
Ma'am, can you repeat the
now there
judgments?
also there would be there just one last thing. You see, even in that case also there will be an issue of registration or not, though Registration Act is a central act, but it is also a state subject, and state has the power to carry out amendments in that. Correct? So therefore, it may be there may be amendment in one particular state where the place of arbitration is.
That is right.
That particular award which is passed in an arbitration is compulsory or mandatorily registrable. So you have to. So this answer would anyway be. I mean, this question can be answered only relating to the place of the arbitration.
The seat of the arbitration, whether it's Mumbai, Delhi, Gujarat, Pune, Lucknow, it would depend on that.
I think Rashi also had one question. Yes, Rashi. Hello, Rashi, you raised the hand, yeah?
I think it was some mistake.
Ma'am, I have a question. So can you repeat the judgment you last mentioned?
Vidya Jolia. I'll try and type it in the chat box. It's it's November 2020 from the Supreme Court. VIDYA
Ma'am, just to reassure, it is the same statement that gives us 6 kinds of disputes which are not arbitrable, right?
Yes. So that judgment particularly dealt with whether leave and license agreements would be arbitrable or not. But while saying whether or not they were arbitrable, the judgment also laid down all of the other kinds of disputes, whether they would be arbitrable or not, and it traced the history of the law of arbitrability in India as well. So, which is why it would be useful for everyone to pick this judgment up and read.
So I think, sir, do we have the permission to now go and enjoy our weekend?
Definitely, sir. Just a token of thanks and appreciation, sir. We would like to add it here. I will take 5 more minutes, sir.
All right.
Yes, Nikhil, please.
No issues.
Thank you so much, sir and ma'am. And now we have came to the end of this lively gathering and this wonderful session. It has been my pleasure to moderate the session. I express my heartfelt gratitude on behalf of our organizing committee, entire law department of JCRC University, amicus curiae, and all the faculties of law to take this opportunity to thank our distinguished speakers, Mr. Sameer Shah and Ms. Chinmayee Pendse, for giving their valuable insights. It was very knowledgeable session, and we are indeed grateful to witness such an insightful session. I hope all participants were enlightened with a deep understanding over this subject. Now, I humbly request Dr. Namita Jain ma'am, Head of Department, Faculty of Law, JCRC University, to facilitate the e-memento to Mr. Sameer Shah, sir.
Thank you so much, sir, for such an informative and interactive session. And मैं start में ही आपको thank you बोली थी और last में फिर thank you बोल रही हूँ. The word thank you is very small for you. So thank you so much, sir.
No, ma'am, it's really my pleasure. And I have always been looking out for these kind of, interaction and opportunities to contribute, make a humble contribution for the benefits of the students and the younger generation, because when I used to study, I mean, we didn't had these kind of exposures or these kind of technologies or even the education system as such, which the current generation is blessed with. The idea is to just guide them on a right path, how best they can use these blessings to their own advantage. That's the only purpose. So thank you again for inviting me, and I also want to propose a special thanks to Chinmayee for taking out time and supporting me on this. I mean, she was, so quick in saying yes on just one small, simple phone call. And, on a weekend, I mean, spending this much time with such interactive presentations. So thank you, Chinmayee, for making it so lively. And I'm sure that the participants also would agree with me on this part. So thank you again. Thank you so much.
Thank you
Thank you so much, sir. Also, now I would like to request Mr. Pankaj Awasthi, sir, Assistant Professor, Faculty of Law, GCRC University, to facilitate the e-memento to Ms. Chinmayee Pendse, ma'am. Sir, please.
Thank you, ma'am. I think thank you is not just the word enough for you. The efforts you have made in. So, but still, it has to be there that we are very highly delighted and thankful to you to be here and on our request. And I am sure that students have learned a lot from all these things, because the drafting of an arbitration clause on to say it arbitration agreement is one of the important aspect when they go into their legal careers as a legal professional. So having a delightful session and insight view of the arbitration agreement, we are very happy to have you here, ma'am. Thank you so much.
Having me. It was an absolute pleasure, and I look forward to being associated with JCRC in going forward as well.
Definitely.
So, so all the participants who are still there, let me take this cue from what Chinmayee said and take maximum advantage of social media. Follow her like anything on LinkedIn, yeah, and it will be for your benefit.
Definitely, I'm happy to help as many of you as I can.
Thank you.
Thank you, sir. Thank you. So all of you have a nice weekend ahead. And I think we'll be meeting tomorrow itself again. Yes?
Yes, sir.
Yes, sir.
Thank you, sir. Thank you, ma'am.
Thank you.
Thank you.
Thank you so much, ma'am. Thank you. Thank you.
So there is an announcement for the dear participants that we have posted our Google